Hi, my name is Jordan Walker. I'm an attorney with the law firm of Sever Walker Padgitt. We are an eminent domain only law firm. This is the only type of law we do. And forgive me, this keeps going away. Uh, uh, we are a landowner only eminent domain law firm. This is the only area of law we do. We only do eminent domain, and we only represent landowners. So I've gotten some calls on this project, kind of curious about who we are, what we're doing, who are we acting on behalf of, and the answer is we are here on behalf of landowners. We do not work with ITC. We have never worked with a utility company. We have never worked with a condemner. That means anybody who can take land from landowners. We do not work for them. We only work for landowners such as yourself that are in this situation with ITC, wherein they will eventually come in and want to take your land for this project. So I do like to say that at the outset, because a lot of folks aren't really sure, what we're doing and why we're out here. So I like to say that, before we get into it. Again, we are eminent domain only, and not only we are eminent domain only, we have done hundreds of pipeline cases across the country. We have represented landowners all over the country with regards to pipeline acquisitions, utility acquisitions, power line acquisitions. Sorry, it should be hundreds of pipeline and power line. Let's go ahead and put that in there as well. We have done quite a bit of utility work across the Midwest, across the country. And that's all to say that we have learned quite a bit about how these utility acquisitions play out. We've seen the same thing time and time again. We've seen acquisitions of all sorts on all sorts of properties affecting Christmas tree farms, agricultural properties, mining operations, you name it. We've experienced it. We've been a part of it, representing landowners. And as a consequence, again, we learned quite a bit. We know how these acquisitions play out. We know what to look for on these easements that they're going to propose to you. The pitfalls that may exist in these projects, we are familiar with them. So, with that being said, we've learned quite a bit. And so, the job of me today with you guys is to relay that experience, relay that education that we have gotten over the last 15 to 20 years of legal eminent domain experience. So that's what we're going to be doing today, talking about what to look for during this acquisition, what to be prepared for. We're going to talk about Michigan law, the Michigan procedure for condemnation here in a bit. We're going to talk about the project a little bit, exactly what it is and what's happening. I do want to note that we are going to have in-person seminars here eventually. I understand that webinar is not great for everybody from a technological perspective. We will be coming out and meeting with landowners in person. You will receive letters to that effect, just like you received letters about this webinar here at the end of 2024, probably early 2025. So if you are a landowner who's having issues accessing this webinar, you know somebody who maybe isn't able to join us today because of some technological reason, that's fine. This webinar will be on YouTube, and we will have in-person seminars discussing much of this and more later this year, early next year. So let's talk about the project. The Michigan Grid Project. It's actually two different projects that have been kind of merged into one larger grid reconstruction or construction project. There's the Helix Hipple line, which is 55 miles of a 345 kV, 345 kV lines. They'll be constructed basically from the Indiana border up to almost Lansing and to the new substation, I should say. And then I should also note that for purposes of kV, 345 determines effectively the wattage, the power generation, transmission of these lines. I would say the smallest, the local easements, local power lines you maybe see along the road, those are usually around 100, maybe less kV. They're much less voltage, smaller voltage, so consequently they are much smaller lines. 345 is a large kV. It isn't the largest they get or the most wattage they get, but it's a voltage they get, but it is towards the higher end. They can get up to 500, 600, I believe. But nonetheless, that's all to say that these are not insignificant structures that are going to be built on the property, and the lines that go with them, of course. So it's not like a local power line you see along a local road. This is going to be those big ones you see that go right through the middle of the farms to transmit the power. And so the Helix Hipple is one project, and then there's also the Nelson Road Oneida project. That's 40 miles again of a 345 new 345 kV transmission line, uh, and that again will be going from Oneida to the Nelson Road substation in New Haven. And I do want to note that there are maps available at ITC's website. Heaven forbid we, I don't generally like to refer to ITC and their resources and materials, but they do have detailed maps on the that website right there, mifuturegrid.com. So if you're curious about how this route is going to cross your property, there are maps. I believe they go parcel by parcel. So if you go to mifuturegrid.com and play around with it, you should be able to find your parcel and how it is being affected by these projects. So that is kind of a 10,000-foot view of the power lines that we're dealing with right now. As far as the process and what we're looking at from a timeline perspective, so the way utility projects work in Michigan and how they work in a lot of different states is that usually some sort of public service commission, in this case the Michigan Public Services Commission, has to approve the project. This isn't always the case, but most states have some sort of utility regulatory infrastructure to approve and review these types of projects, and Michigan does. And they are currently before that commission. Basically, the commission's duty is to ensure that the project is being built appropriately in consideration of environmental impacts, landowner impacts, et cetera, and so forth. It is expected that they will get approval for this project, both lines. Now, that's not always the case. It wouldn't be the first line that was ever rejected, but for the purposes of this presentation, we're going to assume that the project is approved and approved for construction, and it will move forward eventually. It is important to note that for each project, ITC submitted a proposed route and an alternate route, again, for each line. We only mailed to the proposed route, so if you received a letter, that's because you were on the proposed or primary route. It is certainly possible that this line's route may change. It may change significantly, although I doubt it. It might have some minor changes. I would expect some small minor changes as they get into land acquisition and they get further into surveying the land and understanding what they want to build. So it's possible that the route will change. We can't know that, of course. These route changes may reveal themselves at the Michigan Public Services Commission, but ultimately, ITC is going to come to you if they want your land. And one of the questions I get a lot in this line of work on this project and any project is, how do I know if I'm affected? And first, at least according to our maps, again, the same maps that ITC has submitted to the Michigan Public Services Commission and put on their website, that's a good sign that you're affected if they're identifying your property. But beyond that, ultimately, just them identifying your property on a website somewhere isn't necessarily the end all be all. If your property is affected, you will know because they will come to you and they will try to buy your land. And we'll get to exactly what they need to do here in a bit to buy your property. But just be rest assured that there are statutory requirements in these acquisitions, and ITC if they want your land, which we assume they do for the time being, based on what we know. If they want it, they'll let you know. They'll come out. They'll contact you. They will make their presence felt. We are ahead of this project as we sit, as I understand things. I think of all the folks that register for these webinars, I think only one person indicated having an offer, which is what we understand to be the case. We are a little early on this project. So if you haven't received an offer from the ITC, if you haven't received anything from ITC, that's fine. It isn't something you did wrong. You are not behind the eight ball, or you're not missing anything. So I just want to get that out there also as well to say that we are early in this marketing effort. We're not super early, and we expect offers to be forthcoming here shortly. But it's my understanding that we are a little bit early, and in these scenarios, it's always good to be early as opposed to late. So, with that being said, we are expecting a Michigan Public Services Commission approval or ruling, rather, expected in 2025. And likewise, condemnations such that they would occur would probably happen next year as well. And you can see the schedule. Again, this is pulled from ITC's website. We're almost in 2025. You can see that transmission line easement acquisition there, and this is the same for both Helix and the other project. That we're right. We're according to their schedule, we're looking at transmission line easement acquisition, aka offers, sometime next year. So keep your eyes peeled. If anyone from ITC starts snooping around or showing up or emailing you, calling, contacting, that can inform you that it's likely an offer is forthcoming at some point, or it's on its way. So, and for your purposes, the offer will inform you everything you need to know about the acquisition and what you need to do. So, that's the process. Let's get into exactly what condemnation is. So, condemnation and eminent domain, they can be used and they often are used interchangeably. Um, eh, Condemnation is the procedure by which condemners acquire land and put it to a public use. So basically, it's most often, or I guess most recognized, eminent domain that is for road projects. More often than not, when people think of eminent domain, if they think of anything at all, they think of a road getting widened, and that road, of course, the Michigan Department of Transportation, whoever is widening the road, needing additional land to build that road. And the road has to be built. How does it get built if a landowner doesn't want to sell their land? Well, it gets built because eventually uh, certain entities, ITC being one of them, have the ability to take that land, whether you like it or not. And that power to take is effectively known as eminent domain, the power of condemners, usually government entities, in this case, utility, the power of those entities to acquire land through eminent domain. In other words, the ability to acquire your land whether you like it or not. Uh, ITC will have this authority to utilize a condemnation to acquire your property. And because they have this power, it changes the dynamic of the sale of your property. This isn't a traditional arm's length transaction between you and somebody who wants to buy your property. This is a transaction between you and somebody, an entity that has the ability to take your land, whether you like it or not. That changes, of course, the negotiation postures. It changes the leverage of the scenario, changes everything. So it's not a traditional transaction. ITC has that ability to condemn properties and put them to a public use. In this instance, transmission lines are public uses, much like roads are public uses as well. And I will say that, and I think we're going to touch in a bit, but a lot of people are. I assume that there are some people that are not happy with this project or not happy with eminent domain generally. A lot of people are not, and that's a very common feeling to have in these scenarios. Is that ultimately you don't want to give up your land. You didn't ask for it. It belongs to you. You own it, and now it's being taken from you. It doesn't seem fair. And I think in some respect that's correct. It is relatively unfair, the ability to lose your land that you own to eminent domain. But it's important to recognize that they do have this ability to acquire it. And a lot of people utilize this anger that they don't want to lose their land to try to stop the taking. And our position broadly, is that stopping the taking is certainly something you can do, and it's something that we've done before on behalf of our landowners. And when I mean stop the taking, I mean when they file their condemnation petition, you respond and say, no, you can't exercise eminent domain. We have done that before, but the problem is that the laws are written such that those challenges are very difficult to effectively make. And really, the only effective challenge to a condemnation proceeding at condemnation would be that they didn't follow the law prior to acquiring the land. If you don't like the project as a whole, if you don't want either of the projects and you don't like them just generally, as in addition to not wanting your land to be acquired, the time to launch those arguments would be at the Michigan Public Services Commission right now. And we don't generally do that on behalf of landowners. We're strictly at the condemnation level of the process. But if you if you really don't want this project to happen in general, you don't even need an attorney. You can log on to the Michigan Public Services Commission docket, file a complaint, and tell them that you're not a fan of this project and you don't think it's going to be built. So but ultimately, if you want to stop this taking at the eminent domain level, it's going to be very difficult. You might be able to change the route a little bit. Ultimately, stopping it is going to be very difficult. And a lot of times, even if you are effective in stopping a condemnation on your property, a lot of times all that means is that the utility in this instance can just correct their problems that they had, refile, and then take the land after following the appropriate procedure. So I do like to touch on that a little bit because a lot of folks are curious about stopping these takings sometimes. So I did want to touch on that. And if that's something you're interested in doing, we can absolutely talk about it. And I'm happy to talk about that on a more personal level if that's something you want to do. So when I say that stopping the taking, isn't really much of an option, or it's a very difficult option, you might be curious about what options exist that are even good. And I will say that much like stopping the taking is difficult, getting the right amount of compensation, just compensation as it's referred to, for your land is not as difficult. As a matter of fact, the playing field is much more even when arguing over money, ultimately, or just compensation, what you're entitled to. You are entitled to a jury trial. You can present your evidence in front of a jury and they can render a verdict. So naturally, the playing field's a little more even. So, uh, and I want to talk about how that happens right now. And so we talked about the condemnation, the procedure by which utilities exercise eminent domain. This is a kind of I would say it's a 10,000 foot view of the land acquisition process. It isn't necessarily, I know I labeled it the condemnation process, and it is, but I also included some aspects that maybe are outside of that. This is a more comprehensive timeline of events to expect in this acquisition. So the first thing that I tell people, if they're curious about knowing when this thing is going to happen, the first visual, I guess, revelation of the project, the first time it reveals itself in person is surveyors coming out and looking at your property. If you've seen a land surveyor before, they have all their fancy tools. They survey the property to determine really where the line's going, where the poles should be built, what is the breadth of the easement, how wide is the easement, where is it going to go. That's accomplished by surveyors. And if you have surveyors coming out to your property, it's a fair assumption that you are about to be in the land acquisition process. It isn't necessary. It isn't necessarily the case, but again, if you're starting to see people come out, that means things are starting to happen, and you may soon be receiving an offer. So the first step is surveying. Surveyors come out and they look at, they look at look at the property, they do their surveying. The next step is appraising, where ITC will send an appraiser out to come and appraise the property. That appraisal is important because it will form the basis for the next step, and that is the written good faith offer. So I've said a lot about receiving an offer, and we even asked the question in our registration, have you received an offer? And the reason why we do that is because that is the crucial step, the crucial point in your case, or at least it is the beginning of your case. Because the offer will tell you, again, everything you need to know, or it should tell you everything you need to know about the acquisition. It will issue the offer, money. It will issue a monetary offer. It will present the easement to you that they ultimately want. They should supply a map. They'll probably supply some booklets and some brochures about what they're doing or what they intend on doing. But ultimately, the most important part is that it needs to be in writing, and it will be in writing. It has to be in writing if they want to file their condemnation complaint ultimately. So you will get a written good faith offer. And like I said, if your property is affected, if your property is not affected, you are not likely to get a good faith offer. So again, you're not likely to get an offer, period, if your property is not affected. And so again, ultimately, if you don't get an offer, if ITC never comes to you and never issues you an offer, then that means that for whatever reason, they didn't need your land. If they do, then they do need your land, and you have to respond, and you have to respond appropriately. But we'll get into exactly what to do when you get an offer. I will note that our firm generally gets involved at the written offer stage. If you have an offer, once you get one, if you're curious about whether or not it's a good one, we offer free case reviews. So once you get the offer, or if you have an offer, you can send it to us. We can look at it for free and give you our thoughts, and you can decide what you want to do. Simple enough, but I did want to throw that in there right now. So back to the process. You've received your offer. If you didn't accept it, or let's say a deal can't be reached, ITC can then file a condemnation complaint in the county circuit court where the property is located. So this is the condemnation that I referred to earlier, the procedure. So they'll file a complaint, again, in the county court where the property is located. You'll be served with a copy of that complaint. Now, it's important to note that if you disagree with the amount of money that ITC offered you, then and you're in condemnation, you need to respond to that condemnation complaint. They'll file it, they'll give it to you, and you have to respond and say, we disagree with that amount of money. If you don't, you might not be able to challenge that amount. You might not be able to get more than what's offered. So it's very important to remember that if you have been sued, if you received a condemnation complaint, which you can only receive after you received an offer, it's important that if you got to that point and you haven't contacted an attorney, it's imperative that you contact an attorney at that point, because once you're at litigation, uh, the timelines speed up, things start to happen a lot quicker. You need to be on your toes to make sure you make the necessary filings to preserve your rights at condemnation. It's also important to remember that in Michigan, much like the case in many other states, there is a quick take ability of ITC or the Michigan Department of Transportation or whoever is acquiring land. And quick take, basically, again, this is very common in many different states. In all the states I'm licensed in, which are several. Every condemnation procedure has a quick take ability, and that is basically ITC. If they file their condemnation complaint, they will also have that initial offer, the good faith offer that they issue to you. They will deposit that money effectively, and then with that deposit, they can access the land to begin the project themselves. Uh, and in return, you can withdraw that money if you'd like. You don't need to. You can if you want to. But ultimately, if they deposit that money, it basically acts as a bond that allows ITC to begin the project on your property, despite the fact that compensation hasn't been fully resolved. Because what happens in a quick take scenario, they file their condemnation complaint. Let's say they offered you $50,000. They deposit the $50,000. They get an order that allows them to access your property to begin the project, but you're also allowed the ability to disagree that $50,000 is appropriate compensation. And the case continues on like any other litigation, ultimately ending in a jury trial over what is final compensation or what you're ultimately entitled to. So in this scenario, if you were offered $50,000 and you feel like you're entitled to $100,000, they file their lawsuit, they deposit the 50, the case continues, you hire an attorney, you file your objections to the complaint, you and your counsel negotiate with ITC and ITC's counsel. Eventually, you can't reach a deal. You go to a jury trial. The jury says you're entitled to 100. In that scenario, even though they deposited the 50, you would get 100. That would be the end of the case. And in that scenario, you would have gotten more than what was initially offered by ITC. That is a beginning to end, nuts to bolts, 10,000-foot view of the condemnation process in Michigan. It's, I think, most important to remember that as soon as you get an offer, contact an attorney. If you have been sued, if you received a condemnation complaint, the time to act is yesterday. You need to really get on it if you are being served. So I will say that. So the rest of the presentation, I'm going to talk a lot about pre-condemnation negotiations with ITC. And we're gonna talk. Actually, we're gonna move this slide down. We're gonna get. Let's get to. Let's focus on what happens when you get an offer. So, uh, what to do when you receive an offer? First of all, insist that. Well, let me backtrack. When you receive an offer, you're going to receive an offer from a land agent, a right-of-way agent. These folks are they are hired by ITC, and their duty is to come to you and convince you to sell them your land. That's their job. They get paid depending on how many parcels they lock up for ITC, how many easements they get signed, and for how much money is as minimal as possible if it's them. That's their job. That is a right-of-way agent's job. These are professionals that do this across the country. We work with them or deal with them a lot, unfortunately. But they do this all over the country, and they're going to do it on ITC too. And so just bear in mind who you're dealing with when these folks come in. What I tell people to do, there's I think a foolproof way of handling these right-of-way agent negotiations. And this is when you get that offer. So this is after the appraisal, but before any sort of condemnation. When you receive that written good faith offer, first of all, insist that the right-of-way agent communicate via email only or in writing. If you're not an email person, or text is fine too. Really, ultimately, we like to avoid verbal conversations with right-of-way agents. You need to get everything that they need to say on the record. A verbal promise means nothing if it's not in writing, and you will. It's possible you'll get some verbal promises from these agents that don't necessarily reveal themselves in the ultimate easement that they want you to sign. So it's imperative when you're talking with these folks, try to communicate via email, try to communicate via writing, texting if possible only. Verbal discussions are not going to do you any favors. So what I tell people, the easiest way to do it is uh, once you get a right-of-way agent, either they call you, they email you, inform them right off the jump. Please only communicate with email, and then when the offer is ready, send the offer via email as well. And then when you get the offer, hopefully via email, hopefully they're following your instructions. Inform them, respond via email. Thank you. You will review this and get back to you in a week. So when the right-of-way agent issues the offer, say thanks. You'll look at it. You'll get back to them in a week. Why do I say it like this? I say it. I think this is a good answer to give because, first of all, you're not blowing them off. You're telling them that you're going to respond, and you're not going to make them hurry into a condemnation. You are basically informing them that you're going to do your due diligence, and they should respond and say, "Okay, that's sufficient." They'll probably follow up back in a week. In the interim, once you've received that written offer, you can then just forward it to me or to another attorney, whoever you're hiring to review it, who can then look at the offer and then give you your thoughts or give you their thoughts rather within that week time period. I, for example, can review offers usually within the day. Depending on how much time I have, I can do it within the hour. Uh, so get that offer, forward it to your attorney, forward it to your counselor, and then get an analysis, get a plan at that point. What are you going to do? How is this acquisition going to continue? Is this a case that you want to reach condemnation? Is this a case that maybe you should resolve pre-suit? That's where you develop a plan and a strategy for how you're going to handle the acquisition. So if you follow this, then once you send the offer to your attorney, you should develop a plan, and then you can go from there depending on what your counselor recommends. Again, I would avoid in-person discussions, avoid in-person negotiations. They don't serve the landowner well in these scenarios. If anything, they serve the right-of-way agent well because they can make all sorts of verbal promises that ultimately are not in the documents themselves. So just bear that in mind when you're dealing with the right-of-way agents moving forward. So that's what you should do, and here's what you should not do when dealing with right-of-way agents. Don't engage in negotiations or discuss value or really anything about the property before contacting an attorney. Now, it might seem first nature when you receive this offer to just jump out into a counteroffer or start talking about how you think it's unfair or how you think it's wrong and it's not enough money and your land's actually worth this as opposed to that. It is first nature to do that. I do not recommend jumping in and starting talking about the property. Bear in mind, that right-of-way agents will document all of your conversations that you have. They will write down what you say. They will keep a record. And that record will stay with you as your case moves throughout the process. So anything you say, if you say, "I think my land's worth $100,000 or whatever," they're going to write that down, and they'll know that, and then their boss will know that, and then their attorneys will know that, and it's not going to go away. And so this is an example of, let's provide an example of how this can go wrong. Let's say they come to you, they offer you $50,000. You say, "I'll take 100." They say, "We're not giving you 100." They file their complaint. You hire counsel. You hire me. You hire somebody else. Counsel looks at your offer and says, "Wow, this is really bad. They should be giving you $200,000." Well, at that stage, the problem is you already told Michigan Grid or ITC that you take 50, or you take 100 rather. And they know that. And so they have no interest in negotiating over above 100 because you already said you'd take it, and they're going to assume you're going to take it then, just like you're going to take it now. So that $200,000 figure that you may have been able to accomplish is going to be much more difficult because you already told ITC what you were willing to take. The reality is, especially in power line takings and acquisitions, that you don't know what you're entitled to, because how often do you sell your property, an easement to a power line? You can't know what that impact has on the property, and how that easement will affect the development of the parcel, how it affects the farming of the parcel, so on and so forth. These are all things that need to be considered. And discussing these things without having a plan is a good way to not maximize your return. So I would not recommend doing negotiations before talking to an attorney, getting a plan. I would not get an appraiser, at least not outright. A lot of times appraisals aren't necessary in these cases, and appraisals are expensive. And a lot of times, because they did their appraisal, the landowner feels compelled to get their own, but it isn't always necessary to get an appraisal. Sometimes you can get your deal done. Oftentimes, our cases are resolved without the need for an appraisal, which saves you money, and it moves it. It's quicker, and so on and so forth. So it might be possible that your case does need an appraisal, but my view broadly, is that appraisers aren't really necessary until you're in litigation, because then you need to prove your number. You need to, assuming a number exists, and you need to have testimony, and litigation, of course, makes sense. It might not make sense to get that appraisal beforehand, and ultimately, if you don't need to spend two, three, four, $5,000 to get a eminent domain appraisal, then that's probably a better thing. So I generally don't advise getting an appraisal unless it's necessary. This is something you should talk to your attorney about for sure. We already talked about not meeting in person with right-of-way agents. Again, don't take right-of-way agents' promises at face value. A verbal promise isn't worth the paper it's written on. Anything that they should be willing to do, they should be willing to put pen to paper and write it down. Uh, I'd say that, again, don't assume these utilities, ITC has your interest at heart. Their interest is building this line for as cheaply as possibly, cheaply and as quick as possible. That's it. Anything else, that you may assume they're trying to help you out or benefit you. I'm not going to say they're not, but I tell landowners to operate under the assumption that they are not looking out for you. Uh, they are looking out for themselves. They want to build this line, again, for as cheap and quickly as possible. How do they do that? They get landowners to accept the first offer that's provided to them. That's how the utility wins, is come to you, lowball landowners, get the land cheap and quick with no pushback from the landowners. That's how they win. That's how the landowners lose. Do not assume that they have your interest at heart. At the same time, again, do not make a rush decision, because a rush decision is usually not a great one, because due diligence was not performed. Maybe you missed something that you shouldn't have missed. So just bear in mind, don't make a rush decision, but also don't ignore it altogether. I have folks that contact me that are in litigation sometimes, and there are cases that unfortunately we can't take on at that point. I'm not saying that we don't take cases on at condemnation. We do all the time, but there isn't a guarantee that we're always going to be able to help you. So, and there are a lot of folks that get an offer, don't want to deal with it, don't want to deal with ITC, don't think the project is going to happen, are just upset generally, and they let it lie, and it ends up in a bad spot because they let it lie and nothing happened, and now you're at condemnation and you're not even sure what you're supposed to be doing, whether you should be at condemnation. So that is my advice generally for that. So I do want to talk about what they want from you. Um, and we talked a little bit about the offer. So I want to talk about what specifically they're buying from you, because this, unlike a road project where the DOT buys 100% of your land because they're putting a road on it, meaning, if they need an acre of your lot, they are taking a full acre and they will own it. You will no longer own the acre. That's a road project. In this scenario with ITC, with power lines, with pipelines, utility projects, sometimes they buy full right away, full 100% ownership like road projects, but you're more likely, much more likely to receive an easement offer. And an easement is effectively a deed from the landowner to ITC, but instead of deeding, if you sell your land, for example, if you sell your home to somebody else, you're deeding the property to a new landowner. They own the whole thing. They own 100% of the land. An easement, you are deeding some percentage of the land, unlikely to be 100%. Basically, you're selling the right of ITC to do certain actions in a certain area of your property. You're not selling 100% of the land. You're only selling them, only, I should say, you're selling them the right to build a power line, more or less. And that easement will contain all of the rights that ITC has on your property. And also, I should add, I apologize, I'm going a little over today, so if you have to jump out, that's fine. I have about probably 10 minutes left, just FYI. So anyway, an easement, you're selling the right for them to do something on your property. One question I get in all its forms: will ITC be allowed to do this? Will ITC be allowed to do that? Will they be allowed to build above ground, below ground? What are the remediation procedures, et cetera, so forth. Basically, I get questions of what is ITC allowed to do on the land? And my answer to that is it all depends on what the easement says. And if the easement says they can do it, they can do it. And if the easement says they can't do it, then they can't do it. It's as simple as that. Now, what the reality is that what is told to you is not always what the easement says. So, for example, a right-of-way agent might come to you and say, in a couple months, say, "Okay, we're just building the line. It's going to go over there. Here's the easement. The easement says we can build the line, we can access the line to construct it, and then we'll be gone." They like to minimize the impact, to minimize what they're actually building. Now, what they say might not actually be what the easement says. Now, I have not seen the easements that they're proposing on this project. We already talked about the offers, how we're early, and I haven't seen it, and there aren't very many offers being issued, if at all. With that offer, it'll have the easement, and the easement will say exactly what they're allowed to do. And I can just say from experience, again, I don't know if this is going to be the case on this project specifically, but from what I've seen on virtually every other power line project, is that these easements are not well drafted, and oftentimes have authorities granted to the power line that probably should not be granted. I've seen easements that are proposed to landowners. Again, these are proposed upfront to landowners that allow the power line to have unfettered access to every square inch of the property. This is called a blanket easement, meaning, yeah, it might just have the easement be over on the corner, but also the easement says they can access that corner area from not only the roads, but all four corners of the land. They can come right through your fields to access that. I've seen easements that don't have clauses for future damages and crop losses. Crop loss is going to be a big deal for agricultural properties and for these construction projects. They, I assume, will offer some level of crop loss in their offer initially. I assume that they might not. Ultimately, you're entitled to it. And if they don't, sometimes they will try to limit their liability for these crop damages in the future, and as construction commences. So it's very important. Future damages, they will limit their liability. If their tower falls on your land, you might be joined in on a lawsuit because of their negligence within the easement. So you need to make sure that your liability is protected. Let's say the ground is not properly restored. We've seen that a lot where soil is mixed, topsoil and subsoil get mixed. During construction, they're thrown back on the ground. You have less productive soil. That's putting aside the gigantic towers that they planted right in the middle of your property. It's important that you have clauses that um, that protect you from these damages, or that require that the ITC is only responsible for these issues. One thing that we see a lot is that not only will they grant the right to build one power line, I've seen easements fairly regularly proposed to landowners that allow them to build as many power lines as they'd like. Um, you know, they will say the right to construct one or more power lines, and the easement will apply to the entirety of the property. Meaning, you'll sign an easement thinking, okay, they're just building one line, that's that. But then they'll come in 5 years down the road, 10 years down the road, 20 years down the road, and say we want to build another one. And you say, okay, well, you're gonna have to offer us more money, and they say, no, we're not going to offer you anything. We already bought that right 5 years ago, 10 years ago when you signed this easement. I've seen clauses that allow the right to sell their rights within the easement to pipelines, or to solar farms, or to fiber optic cable. And here's a situation where they sell their easement rights that they acquired from you to a cable company. The cable company pays them a ton of money to lease the easement, and they run fiber optic cable through it. ITC gets the money. The fiber optic cable company gets their right to lay the cable. You get nothing because you already granted them the right to do that through this easement. These are just examples of how these easements require your attention. They require your careful attention, so that it's carefully drafted, and there isn't anything that allows for these additional things to happen. And it's imperative to remember, of course, that easements are forever. Okay, so your easement is going to stick with your property through time until it's extinguished. And very rarely are easements extinguished. And in fact, often, and the only entity that has the right to do it generally is the utility company, and they're not just going to do it. So it's important to remember that if you sell your property, if your kids inherit your property, if wherever the property goes, this easement will be there. And if when your kids inherit it, don't have, I just consider you don't want your children to inherit the problems that arise from the easement that you signed. It's just keep that in mind. It's imperative that these problems might not always be yours, and may become the problems of whoever inherits your property, or buys your property. Easements are forever; they stick with the property. So just keep that in mind. There's very important documents that need your attention. So that's the easement part of it. Really, for these acquisitions, there's two parts to it. There is the easement, and then there's the money. The easement needs to be drafted appropriately, but the money also needs to be right. They need to properly compensate you for your property. And how do they do that? They do that through a proper price per acre. So they look at appropriate comparable properties, the value of your property. There needs to be compensation for crop or timber damages such that they exist. That definitely should be part of a complete compensation package. There should be compensation for anticipated soil and ground damages, or a clause in the easement that requires them to remediate the land to your liking. There needs to be proper consideration for all damages that may exist: fencing, field tile, irrigation, compaction, all of these things, flooding, et cetera, that they need to be considered in the compensation uh, damage ahead of time, or again, it needs to be factored into the easement with strong language that guarantees your reimbursement. And then finally, this is the big one. I would say residual damage. I'm going to underline it and bold it because that's how important it is. So residual damages is basically what is the impact of the existence of the power line on the rest of the parcel. Let's say you have a 40-acre agricultural tract. They need 5 acres, but they're running the easement right through the middle of the 40 acres. They're going to bisect it, and it's going to go right through your prime farm ground. In that scenario, you are not only of course, entitled to the underlying 5 acres of easement that they need, but you're also entitled to the impact that that 5 acre easement has on the other 35, or the entire 40 acres that you own. And that impact is called residual damage. It's called consequential damage. It's called diminution in value. These all mean the same thing, and that is, how does the power line impact the value of the entirety of the parcel? And the reality is that this number can be significant depending on who you ask. A lot of people do not want to own property that has power lines or utilities on it. Some people don't care. Some people do. And if people care about not wanting to live near power lines or not wanting to own land with power lines on it, what are they going to do if that land is available for sale? They're going to pay less for it. How much less are they going to pay? How much less is a willing buyer of your land going to pay because of the introduction of the power line to the property? Depending on who you ask, this number could be significant. I'm talking 20, 30% of the overall value of the parcel. And you can see then why, when you're dealing with right-of-way agents, you're probably not going to hear a lot of discussion about residual damage. They don't want you having that discussion because that discussion brings up numbers that are significantly higher than just quibbling over price per acre. A 10% impact, for example, on a $1 million property is $100,000, of course. So 20%, 200,000. I mean, these are, and if it has a 20% impact on $1 million parcel, you're talking about a significant amount of money that needs to be considered. That is residual damage. So it's important to remember that that's something you are entitled to, and it's something that you should definitely make a part of your negotiations with counsel. And this, of course, the compensation should include this in addition to any bonus payments that may be offered by the utility. Sometimes the utilities offer bonus payments to sign up soon or early. All this would be on top of those offers that are already issued. Okay, folks, I am almost the end. I apologize, I'm going late. I want to talk about hiring an attorney generally. Most attorney for your case specifically, and this is talking about just as from our knowledge of how attorneys work in this field. Attorneys generally bill hourly, do a retainer, or do a contingency. Hourly is what you might imagine, where the attorney works on a specific price per hour, billable hour, and they bill you for the amount of time that they put into a case. On your case, they bill you at that hourly rate. You get an invoice and you pay. Retainer is basically the same way, but in addition to the hourly fee, there's also an upfront amount of money that the attorney bills against. So the attorney asks for $5,000 retainer, that it bills against that $5,000 at whatever the hourly rate is. Usually, hourly requires a retainer, but not always. And again, those are billed as the work occurs, and sometimes you will have to pay some amount up front, usually the retainer, to reserve the services of the attorney. Contingency is different. Contingency basically means the attorney gets paid depending on how much money they get for the landowner. And the fee comes out at the end. So, as an example, if you're offered $50,000 and you're on a contingency fee agreement with your attorney, and the attorney gets you $100,000, the attorney collects a percentage of the amount that it added to the case. Usually, it's a third, and it comes out in the end. Contingency allows a landowner to hire attorneys without paying money up front, and it also it allows the attorney basically to work towards the same goal, that being the most amount of money. And before I get to this important note, I want to note that our firm does both. We do hourly and we do contingency, but generally most of our clients prefer contingency, so that makes up the majority of our work, is that contingency fee contracts. We do that. Landowners usually prefer it because they don't need to come out of pocket. And again, everybody's has the same goal, not that they wouldn't otherwise, but you can trust that your attorney is incentivized in a contingency fee contract because they themselves have skin in the game in that point. All the parties have the same goal, and that's to get as much money as possible or to get just compensation. I want to, and before I'm almost the end, I do want to note again, this is very important. Attorneys' fees and costs of litigation are reimbursable in Michigan. I will repeat, attorney fees and costs of litigation are generally reimbursable in Michigan, meaning if you were to hire an attorney and an attorney collects on the 50,000, let's go back to the offer. You're offered $50,000. You hire an attorney. The attorney gets $100,000. Their fee is a third of the 50 that they add to the case, roughly $17,000. Well, in that scenario, that $17,000 that you would owe the attorney actually gets reimbursed to you, meaning any fees that you incur through attorney's fees or costs generally can be reimbursed in Michigan. That can't be stressed enough. That is good law. A lot of states do not have that law. Michigan does, and allows landowners to pay, I guess, hire attorneys and not need to worry that they're going to come out, not being made whole in this scenario. So something to keep in mind when you're planning and strategizing this case. You do not need to worry about attorney's fees if you get them reimbursed, which is something you can do in the state of Michigan. So keep that in mind. So this is the end of my presentation, folks. I see that there is at least one question. If you have questions, please go ahead and start including them. I will address them one by one. As soon as you receive an offer, these are next steps, things you should be doing. As soon as you receive an offer, you should hire an attorney. Until then, start thinking of a process, vetting your options, considering a strategy of attack. Identify your priorities, goals, things you're worried about to present to your attorney. Strengthen numbers. This is usually not available, but in this scenario, it might be. Power lines, they're more likely to get groups than other types of projects. But basically, if you come to me with 30 landowners that are all a bunch of neighbors are right next to each other, and they all want to hire me, they all want my representation, our firm's representation, and I'm able to do that, I'm able to reduce my fees for everybody. And so that it's not necessary or required, but if you have a group of folks and you come to me and say, we got 10, 15 folks, they all want representation. What can you do for us? We can talk about our fee, and I can potentially lower my fee if you have a group. Regardless, we anticipate representing quite a few landowners on this project specifically, so we will have a kind of de facto informal group regardless, that if you were our client, you'd be a part of. Which it's imperative, or I guess I should say that group. The power of having a lot of clients under one attorney, the power of having a group is immeasurable. The ability to say no in large quantities and reject what ITC is presenting provides a lot of leverage to landowners, more so than they would traditionally have. So if you have a group, you want to create a group, you're interested in something like that, we can talk about it. But ultimately, we assume we're going to have quite a few folks on this project, and you just by joining our firm, you could become part of that. So again, that's the end of this presentation. If you have an offer, feel free to send it to me for review. That's my email address. That's my phone number. You can fax if you'd like. Other than that, I am going to take questions right now. Okay, so here's a question. Well, I'm going to go through all of these. I was told they moved the line and we were not on the line anymore. Why did we get notice? Now that the proceedings with MPSC have started hearings, how likely would they move it again? It's certainly possible that you received a letter and you've been moved off the project. We are going based off the proposed routes that were planned. Ultimately, our information isn't perfect. These are two big projects with a lot of landowners affected. So I apologize if you were moved off and you got one of our letters. That would be my guess as to why you got notice, even though you've been moved off it. How likely will they move it again? With such a big project, it's always possible. I'll say that if they've already moved it off your line, it is less likely, or off your property, it's less likely that they'll move it back on. Generally, once they move it off, it stays off. I'm not going to guarantee that, of course, because I don't work for ITC. Just speaking broadly about my familiarity with that, I'd say that if they moved it off, they're probably going to stay off. And that's again why you got notice. Will you send a copy of this presentation? I absolutely will. This is being recorded. We will have a YouTube. It should send it to you after the fact. If you don't get a YouTube link or a link to this presentation in the next day, just shoot me an email and I will absolutely send you a link. No problem. Um, so, are all attorneys' fees and litigation costs reimbursable in Michigan law, or does this law only refer to land compensation cases? So, I'm not going to talk about other areas of law in Michigan because we are not experts on other areas of law, and we don't do any other area of law, so I don't want to talk about that. As far as attorneys' fees and litigation costs, that is specific, I know, to the condemnation. I can't speak to other cases and whether or not that exists, but I do know in condemnation cases, you can get your attorney's fees reimbursed, and you get your costs reimbursed, the costs you expend in litigation. I can't speak to other cases, unfortunately, other areas of law. It's not our specialty, and I don't like talking about things that I don't know a ton about. Um, Next question: how soon do you expect offers to be made? I would expect that you're going to see offers come out in the next. Again, I don't work for ITC. This is just viewing the schedule, understanding when they want things. I think you're probably going to be talking about the next 6 months or so. 6 months to a year, I think it's fair to expect an offer from them. But ultimately, again, if they need it, they're going to come to you. Next question: does ITC pay for the attorney's fees? They should. They have to under the law, so you might have to make them do it. They might offer some level of attorney fee reimbursement. They might not. We'll see what they do with their offers ultimately. They're not really being made, so we don't really know. We'll see if they offer any. But the long and short of it is that you have the law on your side with regards to that. So whether they offer it or not, you need to make it part of your negotiations. Have you worked in Michigan? Our firm has done work in Michigan before. Yes, that we have. Currently, George Padgitt, who is the Padgitt, Sever Walker Padgitt, is getting licensed in Michigan as we speak. Do you have a range of what the value per foot is for an easement in this type of case? So per foot valuations are, they are done more in the pipeline field. They are sometimes done in the power line sphere as well, and that is kind of valuing these acquisitions based off of price per foot. That's more of kind of price per foot of pipeline on your or power line on your property. That's more of an informal way of negotiating because it doesn't comport with the law for fair market value and condemnation. Your property is valued based on the market, not necessarily on what they acquired other parcels for on this line. So the per foot calculation, it's really tough to nail down on power lines, and they don't generally work like that. I guess pipelines are more a per foot negotiation, and we can talk about that, but it's not really relevant to the power line discussion of it. So it's more of what's the price per acre and how does it affect the parcel from a consequential damage, which can't really be determined on a price per foot basis because each parcel is different. Each parcel has different impacts. Is it possible to get less in litigation versus the original offer? It is possible. I can't guarantee. Attorneys aren't allowed to guarantee, and you could show up at litigation, and land values could decrease in the interim between the offer and litigation, and then you could not get a witness, and then you could not present testimony, and you could get less theoretically. Now, of course, that is a possibility. It's not something where if I see that's a possibility that it's something that we would let happen. Ultimately, it's not something that's happened with us before. We are very choosy on our cases. We don't generally take cases where we think that it's possible that the landowner is going to get less than what was initially offered. The fact that litigation is involved and attorneys get involved means that rarely do the offers slip below where they started. But I, of course, can't make guarantees. Anything can happen at a trial. I can just say that generally it doesn't happen, and it doesn't happen with our clients. on purpose because that's we know how to pick our cases. Do you expect that ICC will do an easement versus buying all the property? Unless they need the substation. A substation, they'll probably require the full 100% right away, all of your land deed versus easement. If they don't need a substation or some other, if they basically they only buy the full land and not an easement when they need to build a substation or something like a building, some sort of instead of just towers, every 100 feet or so. Uh, that would be that's generally the only scenario where they do the full acquisition versus easement. Why? Because easements are a lot cheaper than buying the full land. What access rights do property owners have under the power line? Well, that goes to exactly what I talked about in my easement slide. And your rights to the easement depend on what the easement says. ITC's rights to the easement depends on what the easement says. I will say generally, and this is speaking broadly, having not seen these easements as they haven't been issued yet, that broadly you'll be allowed to farm. You'll be allowed to farm under and through the easement. Are you going to be allowed to build a asphalt road through it? Probably not. Can you put a house on it? No. Can you put trees on it? No. Um, ultimately, what you're allowed to do depends on what the easement says. You will be able to farm under the easement, but you need to make sure that anything that's part of that, any protections that are part of that are also within the easement as well, because there's a lot that is left out of these. Can you say and send a list of examples or reasons landowners have successfully gotten a route like this to change a little? The reason why I don't want to get into that is because we don't do a lot of route change stuff, and I again don't want to speak on things that I'm not competent to talk on. I would say that here's an example. I have a current client in Illinois on a power line, and they have, and we're in the middle of negotiations. They have an acquisition, and the power line was going down basically their property line, but it was in a little bit. It was like 10 or 15 or 20 feet in to the property, so that there existed a strip of land on the other side of the power line that belonged to them. And they came to me and they said, "Well, we'd really like it to be moved over fully onto the property line because we don't want this little strip of land that exists." In that scenario, and it was still on their land. We weren't pushing it entirely off of the land. It was just a small route change to accommodate the property line taking. And the power line worked with us. They agreed to that small change. And I think those types of things, maybe moving it a little bit off the property or moving it a little bit on or staying along the property line, those are the types of things that are more realistic. Moving entirely off usually requires a big move, because when you're changing the lines, the issue is that one change can cause a huge impact on hundreds of other landowners. There's a lot of different landowners that are on this project, and just a small change can affect everybody or affect quite a few landowners. And so it's important to keep that in mind. I will say, okay, so examples of us doing that, the one I just provided. Um, I think that would be a little change that we were able to accomplish. I think those types of changes we have a lot more success with than just full whole scale changes and moves and route changes. I do want to add one important point onto that, because a lot of times landowners, their priority only is to get this thing off their parcel and get it, no matter what. They don't want it on their land. And one of the common things they try to do is then push it onto their neighbor's property or ask that they relocate the entirety of it onto the neighbor's parcel. And sometimes they're successful. The problem with that is it might not be what you want, because what they sometimes do is then just move the power line entirely onto your neighbor's parcel. It's the edge of the easement is on your property line, but it's not on your property. But the power line's still there, and it's right there, but it's just on the other side of the property line. And in that scenario, some landowners are okay with it, but to me, in that scenario where it's just there, it's just on the other side of the property, you're still getting all of the impacts on it. You have to look at it, you have to hear it. It's right there. It's not on your land per se, but it has a lot of the impacts that otherwise exist, but you don't get any money. because they moved it entirely on your neighbor's parcel at your request. You said, I don't want this on my land, move it off. They said, okay, we'll move it off. They push it to your neighbor's parcel. It's still right there. It's just a little bit beyond your property line, and you got no money for it. So again, that's personal preference. Some folks want it. Some folks, that's entirely up to the landowner. Something to consider. Do they have authority to demolish buildings? Yes, they will have the ability to demolish any buildings that are in the easement area. How can we determine for Sue if the line is moved? We also thought we were in the clear on this, but have since been told that it might not be the case. I would, if you are worried about the status of the acquisition on your parcel, I would jump on the docket, the Michigan Public Services Commission docket, and see what they are saying and see what they're talking about. All of this is public record. All of this is in the docket, so you can check that out. You can see what's going on. Again, I would use the Michigan Future Grid website to see what the current iteration of the acquisition is. Ultimately, you know, in the clear. The problem is with eminent domain, with these acquisitions, is you're responding to everything. If they want it, they might change it. We don't know. We can't know for certain, frankly, until the thing has been built. Once it starts, I will say that once it starts being built, once all the land acquisition is wrapped up, then you can have some level of confidence that they're not going to acquire your land. Unfortunately, you have to be very intimately familiar with the project and what's happening with it and what they're doing. So I would follow the docket, the Michigan Public Services docket. I would look at the maps on the ITC website. You might try contacting ITC. I'm not sure how much information they're going to give you, but in any event, in this scenario, you just have to be ready. If they come through, if they change their mind, if they move it back on, if they did this, you just have to be ready, and you are ready now because this presentation has prepared you. So whether they need it or not from you, you'll know when they come in and offer, and you'll be ready. Does our firm have a brick and mortar office in Michigan? We are in the process of setting up our office once Mr. Padgitt is finally licensed in Michigan. Actual difference between easement and eminent domain. Well, they're two different terms, really. An easement is just what they want to buy from you, the document that gives them the right to build the power line. Eminent domain is litigation. It is the power of them to acquire that easement through the court system if they need to. So easement's the document, eminent domain's the power to acquire the easement. Why do you need them to cover attorney's fees if Michigan reimburses them? Well, it isn't necessarily that we need them, it's that you can get them to cover the attorney's fees. So with the if you hire our firm, for example, and we are able to get you a much better document, we're able to get you much more money than what's offered, we can then go to ITC and get those fees reimbursed. That is not the case in many other states. All the other states that we're currently working on projects on do not have attorney's fees recovery statutes. So they will pay the fee that you actually have to incur the fees, I should state. So that's another, maybe this is the difference or the distinction. There needs to be actually attorney's fees incurred. They don't just exist, which means you need a contract that sets forth exactly what they are so that if necessary, you can go to ITC and say, yes, they exist. These are attorney's fees incurred. You need to pay for them because of this contract. So you need a contract that sets forth the fees so that you can then get them reimbursed. That's why. Does attorney compensation apply only for condemnation? Again, this is a question that I can only talk about condemnation and not other areas of law. In the Michigan law says that attorney's fees are reimbursable in condemnations. Can't speak to other areas of law. Attorney's fees reimbursed from who? Where does the money come from? ITC is only offering a set amount of attorney's fees. So ITC needs to reimburse the attorney's fees. That is the statute. Now so it sounds like they are offering some amount of money for these attorney's fees, but that's just based on what they think or estimate them to be. That is good that at least they are offering something, but that's just what they believe them to be. They might be much more than that. Regardless, whatever you incur for your case, they should be reimbursed by ITC at the outset, and if necessary, an eminent domain. Next question: if I decline to hear a verbal offer over the phone, does that move it directly to condemnation? No, because they need to make a written good faith offer. Written good faith offer. Those are all requirements for a pre-suit to happen pre-suit before condemnation. A verbal offer over the phone is not a written good faith offer, and it needs to be written uh, beyond it being part of the law. But they need to demonstrate to the court that a written offer was actually given, and they can only do that if there's a writing. So they might try to do a verbal offer, but ultimately they can't sue because they didn't follow the law, the pre-suit. Can the power lines go over a home or planned home building? The power lines can go wherever they'd like them to go, generally, unless the Michigan Public Service Commission rejects their route, says you can't go there. That's why eminent domain, again, is a responsive area of law. They do these things, they cause these issues, they affect your land, they go over buildings, and you need to respond. And you need to either negotiate them away from that or pay them or have them pay you the impact that it's going to cause on you and your property. So, yes, they can go over buildings, they can go over homes, they can go over wherever they like. Now, ultimately, if they go over your house, they're also going to demolish your house. If they go through your shed, they're going to have to demolish your shed. They're not going to allow improvements, structures, or anything to be on the easement, and you don't want them to be on the easement anyway. Nobody wants to live underneath the power line, literally. So they will. They can absolutely go where they want to, but you need to make sure that all of your concerns are addressed, whatever those may be. How far from existing buildings, wetlands, eagles' nests can they encroach? I'm not going to say I don't know specifically about the eagle's nest and the wetlands. That's more of a regulatory determination. That's something for the Michigan Public Services Commission. But ultimately, at eminent domain, they can again acquire wherever they need to go. If they need to go over your building, they'll go over the building. If they need to go over wetlands, they'll go over the wetlands. If they have the ability to do so, such has been granted by the Michigan Public Services Commission. So again, they can go wherever they want as long as they've gotten approval to be there from the Michigan Public Services Commission. Another question: if they change route, do they have to refile? So that's a good question. Let's say they file a lawsuit on your property for an easement on the west side of your property. And that's their plan. They're going to go on the west side. But then all of a sudden, they need to change it for whatever reason. And they need to put it on the east side of the property. What happens then? Can they use that condemnation then to just move the route? The answer is no. If they are requiring, they can't just change the acquisition mid condemnation. They can't just move it across your property. They can't. I mean, I guess they could move it off your property and then abandon the condemnation and withdraw it. That's something they could do, but they can't change the acquisition mid condemnation. They would have to dismiss their own petition and refile a new condemnation petition for the new location that they want to put it. Are easement payments usually lump sum or annual payments? It's a great question. Easement payments are almost always lump sum. That's obviously not ideal. A lot of landowners for leases or annuities or something to that extent, but they don't need to do that, so they don't generally offer it. You're generally only going to get lump sum offers, and that's also how the court defines just compensation as well, through lump sum payments, not annuities. Another question: how many attorneys are in your firm? When was the firm established? So it's me, Phil, George, and Shiloh. So we have four attorneys, all doing eminent domain. We've all been only doing eminent domain for the last 10, 15 years, depending on who you're talking. Actually, 20 years now for Phil. So our firm was established. Sever Story, which doesn't exist anymore. We're now Sever Walker Padgitt. That started in 2009. I think 2009. It was before I joined in 11. So we've been doing this. I think actually it might have been before. I think it was 2008, around there. So we've been doing it for like 16 years. I've been doing it since 2011 when I became an attorney. This is the only area of law I practice. So the last 14 years has been nothing but eminent domain for me, specifically. Okay. And then thank you. You're welcome, Walt. Thank you for the kind words. And then another question: do we have to pay taxes on the monies received? Excellent question. I can't believe it's taken us this long to get to it. So this is a sale of property. Yes, it is under eminent domain or under threat of eminent domain at least, but it is a sale of property generally. So the easement itself. Well, let me backtrack because I want to state we are not tax attorneys. Tax attorneys are a specific type of attorney. They have a special licensure that I don't have. I'm not a tax attorney. What I will say is, without getting into specifics, it is a sale of property, so it is just like selling property. Now, there does exist. If you've ever sold property and bought new properties, personal anecdote. If you sell a house, you can use the proceeds from that house to buy another house and avoid the capital gains on the sale of the initial home. 1031 transfer. So that is something that is done a lot by landowners in these situations too, where they take the proceeds and put it to buying new land to avoid the taxable impact. Beyond that, there's a lot. It depends on what the money is assigned to, because the easement itself, again, sale of land, capital gains. Crop losses, that's reimbursement of income. Residual damage, you could argue, or you can make an argument that that reduces the basis of the property. Again, I'm not a tax attorney. I would definitely recommend you talk with a tax attorney about the taxable impact of this acquisition. But I will say, again, that it's just like selling land, but it also depends on what the money is itemized as and what it's labeled as. Is it the sale of land? Is it the impact on the remainder? Is it crop damages? Because each one might carry with it different taxable. It might have taxable impact. Another question: unrealized capital gains from lump sum count as reimbursable fees. So that is a question of whether or not that counts as a. I guess so. The tax impact, does that count as a attorney fee or cost? No. It's attorney's fees, so it has to be for an attorney to count as a reimbursable fee. A cost, it is not a cost. Again, so these are, when we talk about reimbursable fees or costs, this is money that is going to third parties to assist you in your litigation. So if it's an attorney's fees, for example, it needs to go to an attorney. If it's a cost, it's going to an appraiser or some cost you incurred at litigation. Unrealized capital gains is neither of those, so it's not a reimbursable fee. Okay, we had quite a few questions, which was great. But I'm still here, so if you guys have any other questions, get them in now while you have me. If you want to ask a question later, that's fine. Just shoot me an email. You can give me a call. Email is probably better because I'll be able to respond quicker. If you have an offer, I'm happy to look at it. Just send it to me. Send it to my email address. Let me get hold on again. Another question. How many people are on this webinar? Well, we've had quite a few. I'll say that. Dozens. How about I say that? A lot of interest. We're going to keep having these. We're going to have in-person seminars as soon as offers start really get going in full force. So if you have somebody who wasn't able to make this one, we're going to be having more. So just keep your eyes peeled in the mail for mailings from us. How will it affect property tax? That's a good question. I would say that you can use it to reduce your basis. I'll say that if you get your property tax after it's been built and your property value, stayed the same or went up, you could theoretically lodge an appeal, property tax appeal. uh, and that is considers the impact of the property's value because of the power line. So it's I would say that the county isn't likely to reduce your owed amount based on the power line, but that doesn't necessarily mean that you can't lodge a tax appeal seeking a lower tax burden after the power line's been built in, or after it's been built on the premise that the property has lost value because of the construction, because of the power line itself. So it probably won't affect it on its own, but you can, if you can use it for purposes of tax appeal if you'd like. Okay. Well, we were at almost an hour and a half. It's been a pleasure. I will say that you guys have been great. Thank you for the questions and thank you for your attention. I appreciate it. Again, if you have questions, if you have an offer you'd like for me to look at, just go ahead and send it to me. Um, and we are more than happy to answer any questions you might have. Another question: does our firm help with tax appeals? We can. If you have a tax appeal, you're looking to or if you have a tax bill you're looking to appeal, contact me, let us know. It's all about value. In eminent domain, you generally want it to go up, and in property taxes, you generally want it to go down. So it's just a matter of arguing value. And thank you for the kind words, everybody. I appreciate that. That means a lot. And I will just go ahead and end this now. But thank you again for your time and your attention. And please don't hesitate to contact me with questions.